Welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk a little bit about your consulate interviews and basically what happens. Now, as you know, anyone knows that's gone to the consulate, you put a lot of preparation generally. I mean, if you don't, then you're not going to get, for sure, you're not going to get an approved visa. But generally, you put a lot of work into the petition. You cross all the T's, you dot all the I's, you make sure that everything is going as it should. And many times, like for example, when my office does the E2s or the L1s, or the R1s, things that take a lot of supporting evidence, that require declarations, affidavits, that require business documents, attorney cover letters, all kinds of stuff. And they being the consulates, many of them will have descriptions on their site as to what's required in the order they want it, in the particular, indicia approved for each kind of visa at that particular consulate. The reality is, once it gets to the consulate, you have about 90 seconds, give or take, to make your case. That's it. They don't allow attorneys in the interview with you, and you make or break your case within 90 seconds. So no matter how great the petition is, and no matter how perfect it may be, when you're up there, if you're not properly prepared within those 60 or 90 seconds, then it's going to be denied. Now, obviously, at some consulates, the time that you're given might be a little more because they might not be as busy, or it might be a little less because they're more busy. But if you give the typical time, the average time of a typical visa petition, you're really looking at less than 2 minutes. So while it may have taken months to prepare it, while you might have had to put, like for example, for the E2, invest $100,000 and so forth, when it all comes down to it, you need to be properly prepared when you go to that interview. So I'll exaggerate. For example, let's say you're doing an L1, managerial L1, and you go to the interview, and the first thing the interview asks you is, what are going to be your duties? And you say something like, well, I don't really know. Boom, it's denied. Okay. You obviously have to review the petition, and especially if your lawyer did it for you, review everything. Review the attorney cover letter, the forms, the exhibits, the supporting letter. Know what your duties are. Know what you're going to be paid. Know what you have been doing. Make sure that it's all accurate, and make sure that you are familiar with the petition before you walk in the door. Now, they have what's called the Foreign Affairs Manual, and the Foreign Affairs Manual changes all the time. That is what consists of the regulations that control basically the consulates. And each Foreign Affairs Manual update may change what you did before. So while you might have submitted everything under the FAM at one point, a month later it might be different. So what I always do is, before the interview, I make sure that the Foreign Affairs Manual has not changed, and if it has, then of course I have to submit either an amendment or change the petition to reflect the new FAMs. The reality is that things are getting more difficult to get approved, and there are more onerous regulations in the FAM, and you need to make sure they're all complied with until things change. That's the way it has to be. So, it's a game that has to be played where, the goalpost keeps moving, and it keeps moving by new regulations in the FAM. And all we do is we go, okay, fine, and we will adjust accordingly and prepare accordingly. Ultimately, if it becomes where due process is clearly being violated, we may have to go to court, but in the interim, we can certainly try to comply with everything that is required in the FAM. So if you go to an interview, again, without your attorney, because your attorney is not allowed into the interview, you need to remember what has occurred. Obviously, if it has been approved, then no problem. You can go on your own merry way, smiling, have your visa, and have at it in the United States. But if it was denied, there are various things that we could do in order to try to rectify it, in order to try to present what evidence is necessary to appease the officer, in order to do what's necessary to try to get the visa approved. So this is what you need to do. The interview is only going to be 1 to 2 minutes, as I've said. So when you go in there, you remember what the officer said to you. You remember what you said to the officer. The moment you walk out of that interview, write down as much as you can about what has occurred. Then you can inform your attorney, by basically just giving them a copy of what you just wrote down. And that puts your attorney in a much better position to know if, in fact, there's a legitimate denial, if there were misconceptions, if a motion to reopen or reconsider needs to be done, if we need to do an advisory opinion because there was an absolute wrong abuse of power. There's all kinds of things that might be able to be done to ultimately help you, but it starts with you letting us know what occurred. And of course, we can contact the consulate and get some kind of rendition of what happened, but it's nice if it comes from you in the first place with an accurate rendition. Obviously, if you say, I answered every question absolutely truthfully and forthrightly, and I was completely honest about everything, and they still denied it. And then later we find out that the officer says of the five questions, 4 of them you said I don't know. There'll be a problem. So being honest with your attorney as to what happened will be the first step in trying to get it resolved. So the consulate interview, as it stands today, is a manner of walking in there as prepared as you can possibly be, and then taking it from there. Okay, if you like the video, click like, subscribe, and more on the coming videos. Thank you.